Hey everybody, good morning. I'm JD Houvener, the host of the Bold Today Show, and you made it. This is a weekly show where I'm a patent attorney and owner here at Bold Patents Law Firm. I'm here to answer all your questions related to patent law that you might have, whether it's process-based questions or if they're more related to the invention and trade secret part of it. Our firm is set up to help entrepreneurs, business owners, inventors out there, first-time inventors that are just getting started. And I wrote a book all about how to do that with bold ideas, the inventor's guide to patents. And so I'll be sending an offer for how to get a copy of that PDF today. If you're the first time viewer and this is an interesting concept, you like the idea of a patent attorney being live, give us a thumbs up and share this with your community on social. We'd love to kind of build this up and have it be a vibrant weekly community. All right. So let me do a first disclaimer here, because we do have a a subject matter that is legal in matter. I want to make sure that everybody knows that this is not the forum to post your confidential information. Do not post anything that's specific to your invention. Keep all the questions hypothetical, okay? And if you can do that at a high level, I think we'll still be able to have a nice productive conversation. If you do want to have a detailed conversation, I encourage you to schedule a free screening session. And by doing that, by taking action, I will reward you by getting you a copy of this book right behind me, Bold Ideas, The Inventor's Guide to Patents. All right, so there's your link to schedule a free screening session with one of our advisors today. Okay, so the agenda today is pretty high level. I have no guest today, unfortunately. I'm going to be answering the AVO questions straight away for those listeners that are on avo.com. I volunteer to answer questions related to patents and trademarks. And so I do that usually at the end of the show. But in case there's any live questions, I will, of course, take those as priority. So without further ado, I will share my screen and see if we can get those AVO questions pulled up. So if you're listening and you have questions, fire those away. No, there's about a 1 to 2 minute delay, especially on the YouTube live feed. So don't be afraid if I don't see your question right away. I will get to it in those 20 or 30 minutes we have together. So it looks like we've got 7 trademark questions and 2 patent questions. So it's a pretty good showing today. So I'll share my screen here and we can walk through those questions today. All right, so here's the dashboard. And if any of you are interested in AVO, it's a great place to go check it out. I'm not trying to pump my own profile up, but I've got 16 reviews here, attorneys that volunteer answering questions. I've answered over 200 questions over the past few years. And the subscriptions that I'm signed up for, well, I volunteer my time. And instead of just writing an answer, I share the answer here on this forum. And it's oftentimes they'll trigger follow-up questions by our live audience. All right, so this first question is related to patent law, and it's from Atlanta, Georgia. Can someone tell me if they have a utility patent? I want to make my own charms and use our version of the button. I'm looking to create my own charms for clogs. So clogs are a type of shoe, right? I imagine. Before I do this, I want to know if Croc has a utility patent on the button used to attach the charm to the shoe. Here's a link to some of the patents that they've found on Gibbets. I guess that's a specific type of shoe. Let's take a look at this. So that link didn't really come up with anything specific. So maybe on a bad link, for some reason, it didn't go through. So what I will say is it is worthwhile, right, before you go to market and start selling a product, to consider whether there may be other patents that are enforceable by other third parties that may be able to go after you for infringement. So making sure that you are clear or free to sell your product without risk of infringement is certainly something to consider. And our firm and a lot of other patent attorneys offer the same solution for what's called a freedom to operate. They want to know whether someone has a freedom to operate, and we give an opinion on to what degree are you free, or what's your risk level, right, in terms of being sued by someone else who has a patent rights on what you're trying to sell. So get with us. You've got our link for a screening session. We'll be happy to review the actual charm you're trying to put on the clog, and if there are any rights held by, Crocs or Gibbets, any of these companies that make these types of shoes, to see if it's going to cover the way that you're trying to sell your charms. All right, let's go back and look at those other questions. Let's do one more on patents, and then we'll jump back to our live audience. This was asked just 5 hours ago out of Jamaica, New York. Can I sue my patent attorney, for having a patent abandoned and not letting me know about it? My patent attorney was paid to put my patent through the process, and was fine. And then all of a sudden, I see that it's abandoned, and I was not made aware of the situation. Ooh, well, this is definitely tricky. Being a patent attorney, this is the number one thing that we, watch and are fearful of, is making sure that clients are in communication, know about what's going on, and certainly will be well advised to not let a patent application go abandoned. Now, the number one place where patent applications do go abandoned is when you file a provisional patent application, and within a year, you have to file the non-provisional, the formal patent application. And if you don't, that original provisional goes abandoned. So usually at the 9 or 10 month mark, we're calling, we're emailing, we're doing everything we can to get a hold of that inventor to say, hey, you've got to file the non-provisional. We're here to help you. Otherwise, it will go abandoned. So I'm hoping that there was something that came up. Maybe there was, some awful event that kept the attorney away, or maybe there was a miscommunication. Emails went to spam. He or she had the wrong phone number. So I'm hoping there's some sort of good, valid reason and justification for that. And for those rare cases, there may be an avenue to revive that application. The other scenario, of course, if there truly was an oversight or a malpractice situation, there are certainly avenues to go down seeking a malpractice claim against that patent attorney. Go to your Department of Defense. You can also look into the USPTO for malpractice. Okay, hope it helps answer your question there. Let's see if we have any live questions from our audience. I don't see any right away, so what I'll do is I'll jump back to our audible questions. All right, excellent. Let me go back, because we had those two on patents, and we have a handful of trademarks. So let's do those questions here, and let's jump in and do a couple and then poke back in to see if we have any live questions. So this one comes out of Chicago, Illinois. They ask, is there a trademark attorney willing to help renew the trademark for MFANC pro bono? The attorney for this had a stroke, and the 501c3 organization needs a renewal. Well, that's a very specific question, and not necessarily a generic legal question. It's more about, hey, someone needs help. So I'm not going to get to that specifically, and we'll go to the next question. What is an acceptable trademark specimen for clothing? My logo is a brand name that I want to get trademarked. My logo has a brand name in cursive, right? I have a T-shirt with my logo that's large and big on the front, and also on the hand tag, on the hang tag. I was also wondering, would this get accepted? The name I want trademarked is on the hang tag, just spelled in cursive, and so is my logo. I was thinking of filing myself, but would it be best to pay extra for a lawyer? I think it's always good to get legal advice, and much beyond the question you're asking. In almost every case, when you speak with an attorney that has got experience in trademark law, they're going to help identify issues, help you solve problems that you may not even have known existed, right? You don't even know the right questions to ask. So it's always beneficial to speak with an attorney who's done this and can help you navigate this complicated process of starting a brand and certainly registering a trademark in the right way. This is what your company is founded on. This is what your customers will know you by, the name, the logo, and you want that to be done right. You don't want to play around with that and cut corners just to save a few bucks. So if you've got the wherewithal, the means to do, hire an attorney, I would recommend it. For your specific question on the tag, yeah, that is what the trademark office will look for. Not necessarily what's on the front of the shirt, right? But actually what's on the tag, because that tag identifies who made the clothing, right? Who makes that apparel, because that's really the source of those goods. And that's what the trademark office is concerned with, is making sure that the brand is associated and helps customers eliminate confusion so they know who made those goods or services. Hope it helps answer your question out there in Fort Lauderdale. Okay, we'll do one more question and we'll jump back and see if we have any live questions. This one is also out of Fort Lauderdale. I think it's the same question as asker. So let me go back over here. This question is out of Raleigh, North Carolina. Can a design mark act as a word mark? If you trademark a logo that has a company name in it, can that protect your company name from being infringed upon as well? in the same class of goods and services? Excellent, excellent question. So yes, there are two main types of trademarks. There are word marks and design marks, right? So this person's asking a very good question. Word marks protect just what you think, right? The English characters, apart from the font or the way they're spelled, or the previous question was about them written in cursive, or if it's about a completely, abstract design that doesn't look like any lettering at all, okay? That is a word mark, okay? And you get protection for, which is a little bit broader, right? Of the actual word, and you also get protections for misspellings of the word or homophones, right? Words that sound like it. And it's a nice benefit, because someone who's maybe a bad actor that's trying to steal your company's goodwill might try to start a competitive company with a sound alike, right? It's not spelled the same. So they're thinking that they can get around your mark when you actually do have rights over sound alike. So word marks are usually preferred and recommended for first-time business owners. A design mark is what a lot of mainstream calls a logo, right? It's actually made of designs and ornamental aspects. The protection you get with a design mark is not the English word, okay? It is literally the design. And the fact that it happens to spell out letters is irrelevant, okay? You can definitely put that in the description. And there may be some benefit if it were to get litigated, because a comment, right, someone in the jury will be able to see that, in fact, it does spell out a certain word. But the benefit of being able to have a sound alike or a misspelling is not going to be benefited by a design mark. And so all those benefits that a word mark has are not going to be imported into what you get with a design mark. So if it's in a specific type of a cursive font, and that's your design mark, okay, well, if there's any type of a modification to that, let's say someone uses a bold, courier type of a typed font, even if it's the same word, and if it's in different color perhaps, they may be able to avoid infringement, because that design mark is not about the actual letters, it's about the way it looks. So if it has a completely different look, you might not be able to get them for infringement. So that's a long-winded answer to your question, but thank you for that. Let me jump back to our live questions. Like, we do have a question here from Keith Andes. I have a glow-in-the-dark industry bar used for tying things down. Can I get a design patent on the process and the cosmetic? So let's see. I have a glow-in-the-dark industry bar. I'm trying to see what that. So is that like an industrial bar for tying things down? I'm guessing that's what you mean, industrial. Can I get a design patent on the process of how to make that bar, or how to tie it down? I think maybe what you're asking for. So there's a few things, different things going on. I'll just kind of walk you through that, and hopefully it helps you, Keith. So if you've got an actual device, right, an apparatus, I'm picturing sort of like a bar or a structural attachment that goes on, let's say, the back of a truck, or some sort of a rig. And that device itself, okay, and made up of multiple parts, is eligible, right, as a utility patent on its own, right, if that is unique, meaning novel. If it's not an obvious version of any other type of a bar or structure or tie down device that's ever been made before, and it has a benefit, right? It actually will help you tie things down quicker, more efficiently, and save time, or whatever it is that you're doing, right? So that's number one. If the way that it looks, the actual appearance of, let's say, the way that the ties attach, or the bar itself, the way that it attaches to the rig or the truck, whatever it is that you're attaching to, you may get a design patent on just the way that it looks, but those are different rights, okay? The utility side protects the functionality, right? What it actually does, right? That maybe helps you tie things down quicker, more efficiently. On the design side, it's going to help you just with the way that it looks, all right? So it's different, right? It doesn't matter that it helps you tie things down. It doesn't even matter that they're hooks, or that it can carry a certain amount of force. It just looks in a certain way, and it has a rounded edge, or it has a beveled corner, and it's got a chamfered corner, and it's relational here and there, and it goes up, roughly this proportion. That's kind of what a design patent will help you with. And you mentioned about process. Okay, so process is another type of patent on the utility side. So I mentioned device, or the actual physical structure. If you're actually trying to get the process patent for, step one, attached bars 1 and 2 on distal and opposing edges. Attach at least one flange to support tie down. Step 3, secure with at least 100 pounds load torque force to get the proper dimensions right. Those steps, that is a method, right? A method of providing a proper tie down. If those steps taken together are unique and non-obvious, then you can get a patent on that process. So Keith, yeah, I'd like you to send an example. It'd be wonderful to take a look at. If it is confidential, if this is something you've come up with and have not yet publicized, I'd encourage you to not share that here in this forum. What I'll do is I'll provide you my email address and also a text-only phone number you can send images to, just so I can take a look at it if we still have time today. All right, so there's my direct email, and there's the number to send a text message to. So thanks for that, Keith. Harley, got a question. I discovered a way to teach second graders high school algebra. Nice, awesome. Can I get a design and utility patent on the books? I don't believe a copyright will protect me because anyone could copy the technique. The same technique can be used to teach other high school math and science subjects to elementary students. Cool, okay. Well, my first hunch is that if you've come across a teaching style, a method of teaching math, right? Teaching them algebra, and it's a process that it may be eligible as a method or a process. If you've got it down to using math terms, like a lowest common denominator number of steps, sort of core number of steps, and that sure you could add 100 other steps to add on to it. But if there were a core set of things, principles, and order operations in order to get them to learn and absorb that material, it's possible that a teaching method is eligible as a type 4 process or method patent. The question is that the best way to enforce your rights in terms of what your overall goal is, okay? And so going forward with a patent, the goal is monetary, right? The goal is to make money. And so if your goal is to make money, you got to make sure you think through the business plan of what you're going for. And so if you are, hoping to have exclusive rights to that method individually, you've got to make sure, obviously, one, that your employer doesn't already have rights to what you're creating. And some folks that have jobs in a public institution, certainly within a large private company, you will be obligated to assign all your inventions to your employer. So first of all, make sure that is true. But assuming you are an independent teacher, or you've got no employment contract that would obligate you to assign your inventions, you then have to think, okay, well, if I'm the only one that's able to practice this method, is it going to serve me to grow a company and start a curriculum based on this method that I've come up with and enforce your rights? Then the following question is, okay, will you actually be able to tell if someone is infringing your method, right? And that is a hard thing to do for most methods and processes, is from the public's perspective, right? You've got a competitor, Mr. and Mrs. Teacher X, that has somehow gotten what got your formula, and they're using your method. The trick will be, can you tell from your public perception, or maybe from speaking with Mr. or Mrs. Teacher X's students, that they are following your patented method? So that's the question. It's the reverse engineerability test. Will you be able to tell from the outside that an infringer is using your method? And if you think you can, if there's some definitive markers or things that are mentioned and it's definitive, then I think it is worth going for patent protection. If not, and it's tenuous, and you're not quite sure if it'd be easy to enforce, I would advise you to go toward the path of copyright. Okay, and I would encourage you to think about copyright in terms of what's written, right, in a physical book, in digital format, and that can protect individual artists that are creators of curriculum, and that is generally the sort of the go-to for most curriculum-based teaching methods, is relying on copyright. And copyright does allow you the protections for actual written work and prevents reproduction of the actual work, okay, and also derivative works. And there's some complicated terms with derivatives, but it does mean basically a change or a subtle modification to that original work. You would also have ownership of that. Okay, so Harley, looks like you have all the rights on your own. You've conducted the research yourself. Well, that's really good. Well, I think that's as far as I want to take it for now, Harley. I think your question is a very good one. If you have, we just want to take it one more layer deeper, I think it would get into the confidential range. So I encourage you to book a screening session if you see the link up above with our firm to help you kind of do an IP assessment to make sure that patents or copyrights is really best suited for you given your specific situation. And you're welcome to send an email directly to me as well. All right. Excellent. Well, it sounds like you're doing great work, by the way. If you're able to teach second graders algebra, that's wonderful. Good job. So I've got just a couple more minutes left. Keep the live questions coming in. I'll do one more trademark question, and then we'll wrap up for the day. All right. This one again comes from Avo, and we have a question out of New York, New York. All right. If applying for a number of goods under a single trademark class, only photographic proof of one of those goods is required to be documented, if I'm not mistaken. How can they prove all the items being applied for in that class? Does the applicant then have to submit, say, 10 photos of each documented specific good in that class? Assuming the business chooses not to operate with a website. Okay, so it's a brick and mortar business, and there's multiple goods with the same class. Well, the USPTO just needs one specimen per class. That is just a rule. So if you're selling, drinkware, okay, coffee cups being one example, they're only going to need you to provide one example, one specimen of proving that you're selling drinkware, and a coffee mug would definitely do. Sure seems like, and you're free to sell any other types of drinkware. But you're not going to get protection for, selling athletic clothing, right? Because it certainly is not drinkware. So as long as it qualifies and is considered to be drinkware, is that whatever the word is? Yeah, glassware. Then that should be fine. So if it helps answer your question, I know trademarks can be a little tricky when it comes to specimens and providing proof therein. So send an email if you have a follow-up question to that. All right, well, we'll stop share and we'll wrap up. You bet, Harley. Nice. Thank you for your questions. And yeah, hopefully we're able to get to what you're looking for. I'm here every week, all right? So if you didn't get a chance to ask your question this week, you're welcome to hop on next week. I'll be here at 9 a.m. Pacific and noon on the East Coast. Send this off to people you may know that are interested, may have questions about patent law, intellectual property, which covers patents, trademarks, copyrights, and trade secrets. I'll be happy to take those questions on as well. Thank you all very much for the time and have a good rest of your day. Go big, go bold.